the Supreme Court has agreed to review a Mississippi law restricting abortions. The case could set the stage for a weakening of Roe versus Wade. There is energy on the right and dread on the left that this may be the test case that could do it, as the anti-abortion forces see it, combined with the changes there have been on the court, Trump's nominees specifically. Also, combined with the migration of science on fetal viability and the like. Tell us the view from the inside of this test case. And to our viewers, this is a decision just to set your clocks and calendars. We likely won't know for another year.
So, Brian, the most important thing to know is that the Supreme Court never has to hear anything. They never have to hear a case. They get 10,000 requests a year to hear cases, and they hear about 65 of them. But they agreed to hear this case. And this case involves a Mississippi law that bans abortion after 15 weeks, which is far earlier than viability, which is at 23 or 24 weeks. And the lower courts found this easily unconstitutional. Very, very conservative judges found it that way. But this case has always been about going to the Supreme Court, so much so that the state of Mississippi didn't even bother trying to have an oral argument in the Court of Appeals because they knew they'd lose. This Mississippi abortion law hasn't had a chance, Brian, in any lower court since the year 1973. And if you pass a bunch of laws after a shift in the composition of the Supreme Court, it's not because the laws changed, it's because the politics have. And if you're someone invested in the reputation of the court as an institutional actor, that's a very dangerous calculus to legitimate. And look, if Mississippi were so interested in human dignity and protecting it, as they say, you have to wonder why it is easier, why it's like harder to vote than it is to buy an assault rifle in the state and the like. Now, your lead-in called this a potential reversal of weakening of Roe versus Wade, but I think that makes it sound like there's only one case, Roe, in question. But in reality, we've had 48 years of precedent after precedent about Roe, some of it decided just 2 years ago. And this case is therefore not just about one outlier decision, it's about nearly 50 years of Supreme Court history. And 2 years ago, Chief Justice Roberts cast the deciding vote to strike down a Louisiana law that restricted abortion. So he crossed over to vote with the so-called liberals on the court. But that was when Justice Ginsburg, Ruth Bader Ginsburg, was on the court. She's not on the court now. She's been replaced by Amy Barrett. And the question is there some other Republican-nominated jurist who would cross over with the chief to try and save both Roe versus Wade and the other 48 years of precedent? And if not, this is going to land in Congress's lap, because right now, Brian, they can pass a law to guarantee abortion rights to everyone in Mississippi and the other 49 states.
Well, let me go there, Neal. How real is that possibility? How likely is that, especially politics being what they are, and electoral politics especially? This could be a narrow window of having the party advantage.
Exactly. So, Congress can pass this just by mere majority vote in both the House and Senate. There may be questions about filibuster in the Senate and the like. But I think this legislation, which would use the preemption power of Congress, which is a time-honored part of Congress's suite of authorities under our Constitution, would simply just say, look, we're leaving the law where it's been since 1973. We're not trying to change it in any way. We're just trying to make sure that the rights that the Supreme Court guaranteed to women across the land will stay guaranteed to them.
Hey, thanks for watching our YouTube channel. You should know that you can follow today's top stories and breaking news and catch up on your favorite MSNBC shows all in one place. Download the NBC News app today.